Everybody, welcome to Gossip Without Prejudice, the show where we don't yet have an intro script. My name is John Socha.
Hi, I'm Lindsey.
We are your co-hosts for today, and today we are joined by Paige Blake as a guest co-host. Thank you so much for joining us, Paige. Say hello.
Hello, everyone. Thank you for having me.
Perfect.
We're so excited you're here.
Yeah, I know. It's been really fantastic to really sort of get off the ground for our first episode. Paige, who the hell are you? Tell the people who you are.
That's a great question. I struggle with that question
On the daily.
Yes. Well, I can do the boring answer, which is I am in my third year of law school right now at Seattle University School of Law.
Go Red Hawks.
Yeah. I'm 25 years old. I've almost forgot. Oh my gosh.
Yeah, I have to think
I
about
can't
it
even, I
these
have to
days.
fight it. I'm solidly in my mid-20s now. So it's like,
Congratulations.
yeah, thank you. It's
One of
frontal
us.
lobe.
Gobble goo.
Things started clicking.
They made you go to law school before that clicked.
Oh, man. Yeah.
You know,
Isn't that crazy?
Yeah, I would say what brought me to law school is having a political science degree
Let's
and
go.
not knowing what to do with it.
You couldn't count. You didn't like blood.
Yeah, and I was like, don't ask me to do that math.
Is there a field of law that you think that you want to go into once you're done with school?
Yes, I do. I'm very interested in family law. I did practice a little bit this past summer.
Hemmat Law Group. Bless
Shout
up.
out to HLG.
Shout out to HLG, friend of the podcast. Also sponsors the podcast, sponsored by HLG. Thank you very much.
Thank you very
Thank
much.
you.
How was that experience for you?
I didn't know what to expect going into it because it was just, my first time ever really getting that type of experience working in a firm.
Yeah.
But it ended up being really great. Like, just the amount of experience that I got and also being able to work with people who, one of my coworkers, she was, I think, about a year in front of where I was, so a year ahead of me. And just seeing where she's at and, 2 years ahead of me, huh? Thank you. 2 years ahead of me. So seeing what, I could look like in 2 years, and it was just, very helpful to hear from her. And, yeah, so it was a really great experience.
Well, Paige, thank you so much for that cogent breakdown. For the folks in the audience, we invited Paige here because we wanted to bring in a little bit of the law student experience as we discussed our stories here. The experience of practice and the experience of learning about how practice might work in theory, maybe sometimes, are two very different perspectives. So we just sort of wanted to layer it all in together. Lindsey, what have you got for us on the agenda for today?
We have a really interesting story. This is fresh. The Washington State court system was hacked literally just 3 days ago at the time of recording. So this was a cybersecurity attack. The spokesperson said they have no reason to believe that it was a targeted attack.
Seems pretty targeted to me.
Right.
I say cap on that assessment. That's a pretty wild take from the people in charge of the court system who clearly have not administered the system ideally somehow.
That's exactly what I thought. I thought, so it's a cybersecurity attack, but it's not a targeted attack. So luckily, I know somebody who's worked in cybersecurity for years. So I asked him. He had two thoughts on this. This could be one of two things. One, it could have been a chance of someone, browsing around, they see a vulnerability, they just decide to hack in, boom, that was it. However, that seems pretty unlikely to me. The other possibility is that it's that weaselly way of saying, no information was stolen, right? So it's like, it's not a targeted attack. They didn't steal anything. So that's the assumption here.
So they didn't want anything from the office of the courts. And is there an underpinning system? Is it like Odyssey or is it the wa.gov domain itself?
So it's specifically Washington Court System's back-end file system. So it's all records, but it's also payments and ledgers, account balances and things like that. And it also seems to be communication. I saw in one particular spot that it seems the phone and email systems of the Washington Administrative Office of the Courts is down.
Honestly,
So
they never picked up their phones anyways. That is no great loss to society.
Well, have you used JIS before?
I think a couple of times. I think you are more
boot it
frequent.
up.
What is JIS?
It's one of the systems that got hacked, right? You go on it and it looks like you're on a computer from the 90s. You have to use your function keys, so you can't, use your mouse. You
Really?
literally have to press X on something you want to select, press enter. You have to move around with the function keys. Part of me is like, could an old system be attacked so easily? I don't know.
Maybe their strategy is that it's so old, no one has the hardware to attack it anymore. Like it's written in,
Too advanced.
it's written in the programming language equivalent of hieroglyphs, and everyone's forgotten it's like C dull. Okay, that was a C# joke. That was for all 2 programmers in the audience.
Nice try.
Yeah, that did not laugh. Python. So
You might be surprised to hear the same system was hacked back in 2013. Only 11 years ago, they encountered the same thing.
guys, but it wasn't targeted.
But it wasn't targeted.
You guys,
They
it wasn't
didn't
targeted.
steal anything. There is currently no evidence. There's no announcements on whether or not anything was stolen from the database. So for now, we can assume there were no data leaks. If there's any more updates, we'll try to keep you guys updated as we can
I
moving
think
forward.
here in like where we can't check the commissioner's calendar, we can't schedule any new hearings. Some aspects of the filing system for the superior courts are down, but some others aren't because, fun fact, we use a patchwork of equally terrible systems across a variety of functions. But that decentralization means that it's hard to take the whole system down at once.
Yeah, so these systems are really decentralized. Many counties in the state use different systems for different bits and pieces, so it's all really specific how this attack is affecting different areas.
And I think this also reminds me of, I think like 6 to 8 months ago, the Seattle Public Library system was
Yes.
also compromised.
I think they're still recovering from that a little
Oh
bit.
my God! And we had
Wild.
a book we couldn't even. My partner went to return a book. I think she had loaned from the library, and she was like, "Yeah, sorry, I couldn't return them. There's a ransomware attack." And it really just goes to show everyone's like, "Oh, our systems are too boring to compromise. Like, there's nothing in it for us." But like, if the Seattle Public Library system is enemy, excommunicado number
need to
one,
get them.
yeah, you can say, you know what we're gonna fuck with? We're gonna fuck with the library. Like if the gunslingers are riding at dawn for the Seattle Public Library, it really goes to show that any system connected to the internet can be compromised.
Absolutely.
I suspect this hack took place on November 4th,
Yes,
the day before the federal election.
Evening of the 3rd. It was Sunday evening. But all the announcements and news didn't come out until Monday morning.
Until Monday morning when all the workers showed up. That timing is very interesting to me because half of the utility of cyber intrusion is to put pressure on the recipient, usually to do something or to refrain from doing something, either paying your ransom or just taking down their cyber capabilities. Practically the day before the election, when state counting and .wa.gov domain systems needed to be functioning at their peak, I suspect the target was at least partially the election itself. Luckily, King County locks that shit down, and the election proceeded uninterrupted. But it really goes to show, the possibilities that could result. Bringing this around right when we were counting ballots, which is a real shame.
And there's a lot of counties that have been seriously affected. Benton County District Court, all jury trials have been rescheduled for a full month out, as well as all criminal trials.
Wow, I did not know it was
Yeah.
impacting this much. Yeah.
We showed up in Snohomish County for a hearing, and the commissioner was like, "Yo, I can't get into paraphrasing. Commissioner did not say yo. Shout out to the Snohomish County Commissioner calendar, friend of the podcast. Anyways, verbatim, he said, "Yo, I can't get into these systems. I can't see the docket. So if a document is not in working copies and it is important, we are rescheduling for December," which really shows that they don't have any faith they're going to fix this anytime soon. Like, this is going to be a long, drawn out process to repair.
Yeah, Benton County specifically had on their website, they're expecting to not have their system up by the end of next week, which is 9 days from today, the day of recording.
The fact that that's an announcement.
Yeah.
We know we won't have anything.
Yup, this is going to take a while.
Frankly, that's so dope.
Yeah.
Honestly. That's sick. When I saw that, they're like, "Hey, the entire court is down. We'll fix it next week." I'm like, "Next week? What are we doing? What are we doing out here, guys?"
Snow week, I guess. Yeah, and it's a lot of these courts are affected. Let's see. Thurston County, which contains the state's capital, Olympia, they're rescheduling all infraction hearings. Customer service counters are open. Bainbridge Island and Monroe are not able to accept any payments, digitally or in person.
Can't pay for it. It's free.
Well,
The bane of every cashier on the planet.
Yeah, that dad
that
joke.
dad joke. Yeah. Sorry, Paige.
got him.
Yeah, sorry.
No, I'm just wondering, like, for people who do need to make those payments, you know,
Yeah.
are they just
Jail.
Yeah.
Boom.
There we go. That's what I was assuming.
It's the right thing to do, honestly. Send them right to jail for circumstances outside their control.
I'm
Yes.
thinking about how much it just honestly just sucks though, because there's so many people that have like there's consequences for not paying those things. I'm assuming, hopefully, that they're like they don't have a system to be like, oh, we'll defer this, you know. So
Honestly, judges that only work in hard copy punch in the air right now. They're
so excited.
Yeah, they're out there in chambers. Vindication, really,
oh my god,
really just the vengeance of the 80s is raining down upon us as we speak. Are there any other updates to the story?
Whitman County's Superior Court has rescheduled this week's hearing, except for criminal and juvenile cases. Each county's really doing their own thing. One county is rescheduling everything except for jury trials. Luckily, King County, where we're here in Seattle, King County contains almost 30% of the state's residents. Our systems are nice and separated, so King County is all set. We didn't really encounter any issues. Is that right? By your...
Well, that is true that you can still access many aspects of the record retrieval system. However, we have a weird hybrid system where our calendaring, certain aspects of our calendaring and commissioner scheduling systems are tied into the domain. So like the systems are up, but practitioners are having an enormous difficulty, at least as of the day of recording, year of our Lord 2024, November 7th, are having an enormous difficulty actually getting anything on the calendar. Now, I'm hoping this can be cleared up much faster than the chronic issues we're seeing in others. All of those counties tie into like a specific private contractor that I think has been compromised as part of the back end, and King County also partially relies on them. This is that issue, the decentralization and variety across the various counties, is why Washington State has no dedicated unified e-filing system, right? Like in Texas, you can e-file from third-party applications across the entire state.
wow, that sounds so nice.
Because they have an API. The court has enabled an API, and every single county, district, superior court uses the same system. Here in Washington, that's not the case. It makes us a lot more difficult to take down as an entire system, but it also makes it a lot more inaccessible.
Yeah.
I think that we should come down on the side of access. We should follow in steps in states like Texas's footsteps.
It's not every day you hear that.
Yeah, not every day. Not every day you hear that, but they do know how to do a good court administration. It's not just Texas. Texas is just the largest state that comes to mind. We should follow in those footsteps because the access implications are so important for people's ability to get their grievances heard, be they civil or criminal. It does introduce some vulnerabilities, but that's why you just have to do it right. You just have to make sure that your systems are funded well enough to get that infrastructure set in place and secured for the long term. But unfortunately, county budgets here in Washington have been slashed every single year. The public defense system here in Washington, like in many other states, is at a breaking point. In fact, there's a lot of controversy about reduction in caseloads. I don't know if you guys have heard anything about this.
Yeah, isn't the ACLU of Washington bringing a case against what county is it? I'm not remembering right now. Did you see that? It was somewhere on the eastern Washington.
I mean, ACLU always suing someone somewhere. Go bless up ACLU. The broad strokes of the controversy is that public defense in Washington, bad. There's a lot more to it than that, but not good. Too many cases, too few practitioners. The pay is low. The hours are long, right? Potent combo.
Yeah.
That's a real triple threat right there. And so the poorest people in Washington are not getting access to. They have representation, but their practitioner can only spend like an hour on their felony case, and that's
not nearly
enough.
enough.
Not nearly enough. Exactly. So we're just pleading out, even if you can maybe go to trial and get acquitted. And so the WSBA has proposed reducing caseloads for public defenders by like 73% per practitioner. You say, gang, let's do it, until you realize that they haven't proposed any solution to actually what to do with those cases that are reassigned. So they're kind of just like, great news, everybody. We're just going to work on fewer cases. And then
things are going to take years
and
years.
then the people in jail are like, wait, hold up. Like, we're not going to hire we're not hiring any new, as of now, we're not hiring any new public defenders. We're not expanding funding to make the courts faster, to hire new judges so hearings proceed, arraignments can move faster than they are now. There's inadequate space in the county jails and holding facilities for all these people to languish. And there's also just constitutional concerns because you have a right to, especially in criminal proceedings, a right to a speedy trial. And there's no plan for that on the table. And so a lot of the judges and commissioners are really concerned because they're like, well, if we reduce these caseloads, what are we going to do with that? And that really reminds me of this sort of this situation, and which sucks because like, it's a really noble cause. I see why the WSBA is proposing it, and I think the public defenders deserve a goddamn break. But I don't know. Public policy when it comes to criminal justice is tough because no one wants to fund the court system in any state.
More people have been taking the bar exam, though, right?
Yeah.
I saw a little while ago that over the years, slowly more and more people have been taking the bar exam, so maybe we'll have more public defenders.
There are, hopefully. I think, 37,000 more law school applicants this year than last year.
Wow.
37,000. Wow.
Yeah.
That's a lot of people.
That is nationwide, but that's a year-over-year increase. That's huge.
Wow.
The trend of more people going to law school is not matched by an equal number of jobs in the legal sector. That is an entire other episode in and of itself. I think it's great that people are going to law school, but man, law school is expensive. Paige, I think you can speak to that.
I know it way too well.
Very,
very scared I'd avoid looking at my loans.
Yeah, as a triple attendee of the UW myself, I have personally bought Anna Marie Causse, the president of the UW, until recently, the president of the UW system, a yacht. Yeah. That was on me. It's on me.
You're welcome.
Dr. Causse, you don't have to give it back. You're good. But yeah, higher education is tough.
Yeah,
it's a tough one.
Hello, everybody. This is Gossip Without Prejudice. Thank you so much for listening. If you would please give us a like, comment, subscribe, share, send to your friends. If you have any stories that you would like to hear, we would love to hear your thoughts. Go to gossipwithoutprejudice.com, click around, let us know what you think, and thank you so much for listening. We do have one important thing to say. We are not lawyers.
And that's the way we like it. Don't get legal advice from a podcast. Thank you so much. Are we set to head into LTBE? Lindsey takes the bar exam. LTBE is a segment on this podcast where I, as someone who works in the legal industry, brings in someone who absolutely doesn't and asks her MBE bar questions. And we see where we land on the multiple choice. So Paige, as a 3L, you are getting put on the spot. You are getting asked these two, and you're both going to give an answer to this multiple choice questions.
When I don't get them right, don't consider that. Don't think about it.
We'll cut the cameras. We're cutting the cameras. Yeah, like, no,
it's all a joke. I was kidding, obviously.
Of course, I knew the right answer.
Yeah.
Well, it's okay because if we both get it wrong, then neither of us looks quite as bad. You know.
So for background, for the folks listening at home, Lindsey has a background in design and sales, and she does work at Hemmat Law like I do. She is not a billing timekeeper or a legal practitioner. She's not a paralegal. She's not a legal assistant. And so that's why we're doing this, because it's funny.
Let's make a fool
it's
of
very
myself.
funny. Meanwhile, I literally have all the answers, so I can never be wrong. So that makes it even better. So Paige, you're going to be riding along with us too. Are you guys ready for your first question?
As ready as I can be.
Okay,
so
perfect.
ready.
LTBE, episode 101. A dance student worked very hard to strengthen her legs, including performing additional activities such as leaping and bounding up multiple flights of stairs in her apartment building.
Impressive.
While she was performing her exercises, one of the janitors in the building warned her that she was bound to get hurt if she keeps it up because there are problems with the floor. That was a quote. Mm-hmm. After falling and breaking a leg due to a loose floorboard, she brought suit against the building owner and management. The building owner wants to testify. The janitor told me, I told her that running too fast is dangerous, and she was bound to get hurt. Is the building owner's statement likely to be held admissible? Do you want me to reread the prompt? There's multiple choice. So,
I think I got the prompt.
You got the prompt?
I think I got it. Yeah.
Got the prompt? Okay. So your options are the four following.
Okay.
Yes, because it is an exception to hearsay as a spontaneous declaration to an opponent party. B, yes, because the building owner can testify and be questioned about what the janitor told him. C, no, because it is irrelevant and immaterial. D, no, because it is hearsay within hearsay, and there are no hearsay exceptions that apply. Do you need... The question is the building owner's statement likely to be held admissible?
Okay, and so it's and just to clarify, it's the janitor that told the building owner.
Allegedly.
Allegedly. And now the building owner wants to offer this in court. Okay.
After falling breaking leg due to a loose floorboard, she brought suit against the building owner. The building owner wants to testify. The janitor told me, I told her that running too fast is dangerous and she was bound to get hurt.
Okay.
Is this statement likely to be held admissible?
I think I'm ready.
I think I'm ready too. I'm gonna go first since you have more background knowledge than me. I don't want to bounce off of your answer.
Okay.
Selfishly of me. I think that I'm gonna go with 4. No, this cannot be admissible in court because the hearsay heresy.
However, they heard you say or something like that.
Yes. Yeah, because it's not like he's not going to be able to testify to anything other than, well, the janitor told me this, so why don't we get the janitor on the stand to say that instead? That's my answer, is that no, it is not admissible.
Perfect.
Yeah, no, that's what I was thinking, D as well. There's just about a million exceptions to hearsay, though, so then I was like, well, I'm like, but it's not spontaneous. It wasn't, A was something about spontaneous something. I'm like, I don't know that I know that. Final answer, D.
Okay. You're locking in D.
Locking in D. Yes.
And you're also locking in D?
Oh, yeah.
D is correct.
Yeah. Oh, thank goodness. Thank goodness. We know things.
This is an out-of-court statement quoting another out-of-court statement. In these cases, each statement must fit an exception to the hearsay rule to be admissible. Sidebar, hearsay, crazy number of exceptions. Honestly, the exceptions to hearsay are bigger than hearsay itself.
What the heck?
I also heard a professor say that emails are hearsay, technically. But it doesn't fucking matter because we always use them because they're out of court documents.
Yeah.
But it doesn't matter because emails and documents are always used. There's a bajillion hearsay exceptions. Anyways, must be admissible. Neither of these falls within any exceptions. Under Federal Rules of Evidence 805, hearsay within hearsay is admissible if each party of the combined statement fits an exception to the hearsay rule. See Boren v. Sable, 10th Circuit, 1989.
I definitely understood what that meant.
Please don't make us read that. In addition, with every increased level of hearsay, there's a corresponding decrease in reliability. That's just common sense. And we really want to avoid double. Honestly, the solution here is just bring the janitor in. Just bring the janitor in and have him testify. Though, honestly, that might also be a bad idea, but this isn't in the question because the janitor said, hey, there's problems with the floor. And if they knew there were problems with the floor and that's why she fell and broke, that's dead ass negligence. He's going, they're big liability. Plaintiff's attorneys sitting there just licking their chops. Answer A is not correct because the circumstances described do not qualify as spontaneous statement to a party opponent. The building owner was not a party opponent to the janitor. Answer B is incorrect because that ignores the problem of double hearsay and does not provide any exception to the hearsay rule. Answer C is incorrect because it's just nonsense. C said because it's irrelevant in material. It's very relevant. So congratulations. You both got the LTB question this.
I think we just passed the bar.
Yeah, you're with the powers vested in me by no one, you are now attorneys. Congratulations, Lindsey and Paige Esquire. And that's our show for today, folks. Thank you so much for listening. We greatly appreciate you joining us for the first podcast. We will be back next week. Please, if you like the show, like our funny chats, share, comment, subscribe, send this to a friend. The bigger the podcast gets, the bigger the topics, and hopefully the bigger the guests we can convince to come and hang out with us. So we greatly appreciate it. And thank you so much, guys. It was so great to have you, Paige.
Yes, thank you so much for joining us. This is a lot of fun.
Yeah, thank you for having me.
Thanks for listening, everybody. Bye.